Just answering questions with waptek. Speed round. The U.S. government's decision to abandon the gold standard in 1933 does not mean the U.S. government or the United States went bankrupt. The 41st congressional session, where they created an official status for the District of Columbia, apparently this was February 21st of 1871 is the designation people give, does not prove that we made a separate government, a secret sub-government, nor does it indicate that they lacked constitutional authority to make this district up. What they did is they didn't want the seat of power for the entire country at the time, if you're not aware of the timing, in a specific state, because that state would have undue importance and there would be a conflict of interest. So they decided to create something that isn't in there. This is a lot like if you have, I'm going to do this, if you have a library and you keep a master list book of all the books in the library on a particular day, just because you're doing, you're basically keeping stock of what you have, auditing yourself. If the book is left in the library, do you have it list itself or not? Because that's actually important. If you're running a computer shop and you have a point of sale terminal in the computer shop to keep track of inventory, this is like the inventory in the library. Do you include the point of sale terminal in your inventory? For tax purposes, you have to. For liability purposes, you have to. For sales purposes, for stock on hand, you cannot. I found that out the hard way. If you do that, you have to go back through all the records and completely redact them because they're wrong, because there's an actual rule in the city I was in at the time, Portland, Oregon, that said you can't do that specifically in a computer shop. Yeah. If you run a used car dealership and you have an official fleet vehicle, it has to be under a separate designation because you can't cross the streams. Yeah, if you have if you run a new car company, you're selling Ford vehicles, and you have a Ford Taurus or whatever, and you're driving around, and it's really old and it shouldn't be listed on and you get in a wreck, you can't use the insurance you do for the vehicles you got from the factory. You have to have separate insurance. You can't do that. Why? Because it's not appropriate usage. For the same reason, you're not supposed to use 12-gauge shotguns to take out a mouse. You got to use slugs. Anyway, this is a joke there. Anyway, but yeah, the ruling on not doing this multi-iterative, escalation of, that's why they created a separate section. Sorry to go off on a tangent. I've been doing that all day. Next, de facto, it means in the fact or in fact. True in fact. It may not be an officially sanctioned anything, but it's understood to be what is happening at the time. De facto also refers to like a standard that's come about simply because of kind of an evolution of things, but it wasn't really something you planned, it's just something you end up with. That's the word, the way it's used now. In the legal system, it means the fact as it is considered, or it is true because it is a fact of reality, therefore it's the truth of the moment, or the truth of the situation. De jure, juris, quantum grammar Nazi, means by law, literally. By juris. In accordance with the law and officially sanctioned, intentionally, not just happenstance, or it just sort of happened, like that data went on. Anyway. The word bar does not spell out some word. It's not an acronym. It was a physical bar or barrier. Bar association you could mean barrier, but it just means bar. Its actual meaning was the short name for that barrier or whatever. It's like barrister sounds like banister kind of thing. They're not related to each other. But it was literally a barrier between people who were official members of the court who were lawyers or attorneys. The words are used interchangeably, and nobody really cares about the difference. There is a subtle difference, but nobody cares. And they would argue on behalf of the plaintiff or the defendant. The plaintiff could be the state, or the defendant could be the state. They don't have to be just one or the other. They could also just be individuals who are arguing a case, and they want their lawyers to go to bat for them. But their client can't cross the bar. They have to be behind the bar so that there's a separation symbolically between the court system and the people, because the court system operates not in rules that are entrapping us, but they have to have rules that are specific to them. The legal system has the right to punish a lawyer in a way you can't be punished. If you're acting in your own defense, legally speaking, you may be told you have to stand behind the bar, symbolically and acknowledging that they can't punish you because you didn't agree to be part of the group. In some jurisdictions, me arguing on my own behalf leaves me a lot more leeway and gives me a lot more power over the court system. On the other hand, some of them will say you must stand in front of the bar. You are before the bar. You're being treated as a real lawyer, which means they won't charge you with contempt. They will charge you with incompetence. You must change that status by demanding. No, they can just say, no, you're not really a lawyer. You don't have any training. And if you show that you aren't competent to understand what you're talking about, we won't let you defend yourself, not because we don't want you to win a case, but because we don't want you to lose. They have a duty to make sure that everybody is represented properly and adversarially with the best possible outcome, so that way it's basically a trial by combat between your champions in front of the bar. This is literally the definition you should use if you want to think about this. This also gives you an idea why you're not allowed to just say, I'm a lawyer. If you do that enough, they'll say you're not allowed to act as a lawyer at all, or even under the color of being a lawyer. Meaning you can't bullshit your way into this. Medieval courtrooms were bizarre messes. Separating the people specifically dealing with the case legally from the general people peanut gallery was important because they would be just, it's a free-for-all. We didn't want to have that. The American Bar Association and also an International Bar Association, which is a much more recent creation, do not require you take an oath of any kind. They don't. You can waive it for a specific reason I'm going to bring up, that you cannot argue. You don't have a right to argue. Your argument's invalid. Yes, that's the way people say in court. That means you're crazy if you argue this. But the American Bar Association doesn't require you to take an oath to anyone or anything of any kind. Individual bars in each state may not do it, and they usually don't. And again, you can force them not to require you take an oath because of a simple trap. I'm going to bring up the Texas Attorney's Oath. I solemnly swear that I will support the constitutions of the United States. That implies that it would allow you to invoke the constitutional rules in other states where applicable, but it would be Texas primarily and the federal one, the U.S. government one. And of this state. I will honestly demean myself in the practice of law. That means I will humble myself. It doesn't mean something like they get spanked or whipped or something. I will discharge my duties, not shooting shit, to my clients to the best of my ability, and that I will conduct myself with integrity and civility in dealing and communicating with the court and parties. I agree that I will not be an asshole in court, and I will treat my client very well, whatever the client may be. I might be defense attorney or prosecutor, but I must do these things. This is the oath, what it says. This is also part of the rules. The Bar Association simply shows that you've been able to pass their exam to show that you're competent to practice law or defend another person. That means you can act as that champion in court. It does not mean that you've sworn an oath to anybody. Now, the only way you can prove that is true is by showing an example of it being done, and not as some sort of joke on The Onion, but a real example. There may be real examples. There are colleges where people will make all sorts of silly things as hazing ceremonies. There are people who do this kind of shit as a joke, which is incredibly stupid, because someone will record it and say it's real. But the last part of that oath I'm going to read to you is the part that makes it to where you don't have to take it, and is the reason it's not been required. In Texas, you have to end your statement by saying, "So help me God," according to one version. I'm an atheist. If you make me swear something to God, by definition I've just committed perjury. And this is recognized nationally, even though they don't talk about it, for the same reason they don't talk about the fact that you can't regulate an AR-15. Because it doesn't have an upper-lower receiver combined. Not a fused one, it's separate. Legally speaking, it can't be regulated by the ATF, and it's the reason they don't want a court case on that. For the same reason, in court, you cannot compel someone to say, answer this question, do you like beating your wife? If you make me say something that has any combination, without knowing the previous circumstances, that would compel me to commit perjury, it is not legal for you to compel me to commit perjury. For the same reason, it's not legal for you to make me witness against myself under invoking the Fifth Amendment, or whatever it is. Or are you taking the Fifth Amendment? Is that right? I'm not required to give you evidence against myself. You have to be able to find it adversarially and punish me without me ever participating. I'm not required to give you anything or testify against myself. I am not required to be compelled to commit a crime so that you have a retroactive ability to prosecute me. This has been done enough in court that it's recognized, even though they don't say it. It's been passed as a precedent. It's already been done. If you do something that would cause me to change from being to be compliant with the law to violating the law by compelling me, it's illegal, and I'm not held responsible for it. You cannot compel me to say I agree or solemnly swear or declare an oath to God because I'm an atheist, and by definition I'd be lying. So you can't make me do that. Oh, you have to make a secular version? Okay, get every Republican in the state to agree to make a secularized version that doesn't involve God at every fucking opportunity, because these cunts won't leave it out of everything, including our money. Actually, that's not going to happen. But it does mean that I can't be forced to do that unless you make a separate version. It has to be written out that way. And it has to be an officially recognized version. It can't be a special version just for me. That's why a lot of them omit this shit. I swear and affirm is the neutral version. The other one is, I agree that I will be punished to the fullest extent of the law just because I'm a lawyer if I violate these rules, is actually what it really means. And a lot of them just say that, under penalty of the legal system being able to punish their own. Your champion must be on his best behavior. And that also means that if your champion does something underhanded to screw you over and throw you under a bus, it's a violation of the law. He loses the ability to practice law. Or should. Now, let's contrast that with, I do sincerely promise and swear that I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth II, or whoever it is, as lawful sovereign of insert country name here, very important, an oath to be a barrister or whatever, has to include an oath to the Queen of whatever country you're in, the Queen of Canada, of New Zealand, not Queen of England. If you state while you're in Canada, I swear on my honor under authority of the Queen of England, you're stating it's not the Queen of Canada if she's the Queen of Canada as well. Her full title is this long thing including Wales and stuff. No, really. If you say Queen of England, then it's not the Queen of Canada, because at the time the Queen was ruler of Canada, the acknowledged monarch. Not a separate queen. And you had to state which one, her name, or the King of England. So you have to show an example of a bar association person saying that they swear allegiance to, or whatever, of the current monarch of the United States. It would be the colonies of the United States, the colonies of America, or the American colonies, or the British colonies of America. Why would you think an American organization would require an oath to a Queen of England that we're not underneath control over? Why would someone make up an alternate universe like this and not involve at least one example of Black Widow running around in that tight outfit? Or at least Rocket Raccoon. Your Marvel Universe logic doesn't work in reality. Anyway, a bunch of assertions were made under my channel videos, and I decided to have a little more fun by just pointing out this preposterous shit doesn't match up with anything unless you prove it, and nobody makes an attempt at it. Would anybody like to give me proof of any of these that's real, that's documented, that's part of history? Instead of claiming, oh, I found it in a shoebox someplace, or somebody told me about it. Now, give me some proof. Let's start with the Bar Association oath. Give me an example.